Thank you very much. Yes, there you go.
So, my lords, we're looking at the discharge letter in the supplemental bundle at page 25. It's a letter dated 25th of April 2023. This decision that was the subject of the review.
Yes.
My lords have already drawn my attention to paragraph 2, which sets out that the appellant was considered to be in priority need because he had dependent children who usually lived with him, and that was based on the 3 children that you claim child benefit for. And then over the page, paragraphs G and H, it sets out the reason for the decision based on suitability. So at G, the offer of accommodation was considered suitable as the children have been removed from your care by police. And then further down, it says about line 5, the accommodation booked for you was assessed as suitable for you based on your household needs at the point of presentation. Which doesn't seem to make much sense because when he presented as homeless, he had the children with him. But that was the discharge decision. I don't think we need to look at it.
Sent on the same day as the final warning letter.
Yes. Then he stayed there on the night of the 25th, so he left on the 26th. He requests a review of this decision. The respondents agreed to carry out the review. The accommodation is re-offered to him, and the solicitors make representations on the review. They make a number of different letters of representations, but page 58 is a letter of 7th of June 23. This adds some of the chronology. So on page 59 there's a heading background. At the bottom of the page we can see that the client began self-funding hotel accommodation for himself, his children and his 2 dogs at Paynton Seafront Travel Lodge. He ran out of money. Going over the page, page 60, he was in a storage container with the children. Client advised he was arrested so that the police could remove him in order to speak to his children on their own. Client advised the police advised children couldn't stay at the storage container, and they took them to stay with the client's wife. And then he went to the Roborough Travel Lodge with his dog. And then on the 21st he's offered the seascape. And then just skipping a paragraph, the client advises he didn't hear back from his housing officer, unable to arrange anywhere else for his dogs, so he instead self-funded hotel accommodation over the weekend. 2 of his children also stayed with him, so he did have 2 of his children prior to the offer on the 24th. And then on the 24th of April, he's made the offer. And then the bottom of the page, page 60, on the 25th of April, he nevertheless stayed at the seascape because he managed to find somewhere else for his dog. And on the 26th, he received a letter from the council, a letter dated 25th, advising that they ended their duty. And then the representations are on page 65. So the first full paragraph on page 65, he'd been repeatedly told by housing officers that his children shouldn't or cannot be accommodated with him, supposedly because of some comments made by social services. In fact, minutes from the child protection meeting in February only raised one issue, which was that he had no suitable accommodation.
Where are you?
Page 65, first full paragraph begins, our client has repeatedly been told.
Which paragraph?
First full paragraph, so 4th line, our client has repeatedly been told.
Thank you.
then looking at the penultimate paragraph, he deals with the accusation they were removed from his care by police. He said they were taken to stay with their mother on a single night when the client had nowhere else for them to stay, which had forced him to stay in his storage container. And we know that subsequently two of the children returned to live with him and he went to the hotel with them. And then this last paragraph is really important on page 65. The client's lack of accommodation, both at the time of the social worker's report and at the time of police involvement, had arguably been caused by the council's failure to provide him with such. So basically what's being said is, you accepted he had a priority need on the basis he needs to be accommodated with the children. You didn't provide him with accommodation for the children. Therefore the children were removed from him. And then you turned around and said, oh, well, you don't need to reside with the children anymore because they've been taken off you. Making the point that the council shouldn't be able to rely on their own we say, a breach of the legislation by not providing accommodation, and that allowed him to be accommodated with his children. Then bottom of 65, going to the top of 66, if the council had met their legal duties by providing suitable accommodation, then it's clear the police wouldn't have been involved in April, and there'd be no question of whether or not the children should be able to stay with the father. The same applies going forward. If the council provides the client with suitable accommodation for him and his children, which is legally obliged to do anyway, there's no issue of the client's children living with him. Making the point that the council have created the situation by not accommodating him with the children, and therefore they shouldn't be able to turn around and say, oh, the children aren't with you, therefore we're not providing accommodation for you and the children. Then that takes us to the core bundle, where we have the review decision letter and the judgment from below. So if we look firstly at the review decision letter, that is on page 80. So the decision is on page 81, paragraph 12, 13, 14, which basically says that we're relying on 1936B, you've become homeless intentionally from accommodation made available. Paragraph 18 and 19, they confirm that it was an error to have made the offer under 188, going back to my next question. But that was corrected by the offer letter on the 24th of April, see paragraph 19. And then we get to the crux of the decision on page 85. So paragraph just above 42, there's a heading, council did not offer suitable accommodation. So this is where they deal with suitability. It all kind of blends into one with reasonable to continue to occupy. So paragraph 42, they say they consider the room to have been suitable and reasonable for you to occupy.
Mr. Van Heegen, I don't want to be unkind, but are you submitting that we as a court should hold that because of the factual background, the respondent is not entitled to rely upon the fact that the children were not with him in April? Because if you are submitting that, I, for one, have not seen that as part of your case this far.
Our case is that they decided that the children, some of the children, were residing with him, reasonably expected to reside with him. They maintained that decision throughout, and therefore it was not open to them at a point in time to offer accommodation that the children couldn't occupy, because that accommodation was not available, because it was accommodation the children couldn't occupy, and also it was not reasonable for him to continue to occupy. So it may have been that, well, we know that on one night the children are taken from the container and removed from his care. They would then return to him. But at no point in this decision-making process do the respondents say, oh, we've changed our mind now. We don't think the children should be residing with you. Quite to the contrary, and we'll see this now in the review, they always maintain their decision that the children should be with him. And it's always their intention to find accommodation which is big enough for him and the children. So then paragraph 46, they say that the children had accommodation available to them at their mother's, they're expected to reside there. But if one looks at paragraph 52, they don't change their underlying decision. At no point was the decision not to provide accommodations to the children communicated to you as a permanent conclusion by any party involved. Long-term housing needs of the household remained recognised as inclusive of the children.
This is all long term.
Yes.
Well, I'm very sorry, I'm being very stupid. But what's that got to do with the reasonableness or not of a short-term booking which is initially made for 5 days, extendable?
So it's relevant both to availability and reasonable to continue to occupy. Having decided that the children reside or are reasonably expected to reside with him, they must provide accommodation that's available for those children. It's no good saying we'll do that in the long term, because 176 requires any accommodation that's provided to be available to the children, and it's not. So this accommodation is never available. And as for reasonable to continue to occupy, reasonable to continue to occupy involves looking over a period of time. So even if, and we don't accept this, but even if it was appropriate to separate him from his children for a short period of time, that goes to suitability. It does not go to reasonable to continue to occupy. Having accepted that he should remain with the children, it's not reasonable for him to continue to occupy accommodation which doesn't have the children. Because any contrary decision is simply to conflate suitability and reasonable to continue to occupy, and rob reasonable to continue to occupy of any meaning. So that's why we rely on paragraphs 52, paragraphs 53, because it was consistently the respondent's decision that he should reside with the children. And having made that decision, they could not, we say as a matter of law, offer accommodation that wasn't available to the children. Further, vis-a-vis reasonable to continue to occupy, submitted that the accommodation must be reasonable to continue to occupy, not only for the applicant, but also for those reasonably expected to reside with him, i.e. it must be reasonable to continue to occupy for the children. If they can't even occupy the accommodation, it's not reasonable for them to continue to occupy. So it's unavailable to the children and not reasonable for them to continue to occupy. And then going over the page to pages 87, 88. Paragraph 60 concludes that the accommodation is suitable. And then it says, I'm satisfied the accommodation provided to you cannot be argued as unsuitable on the ground of it not being made available to the household. Well, availability and suitability have got nothing to do with each other. If it's not available, it's not available, and that's the end of it. And then there's a decision at this point that the accommodation is suitable, which in my submission, as I said before, is irrelevant. And then we have a heading reasonable to continue to occupy. And the conclusion at paragraph 62, the accommodation was reasonable to continue to occupy. And they said, paragraph 63, I'm satisfied that it would have been reasonable for you to continue to occupy at the point in time immediately before the deliberate action you took, which I've decided led to becoming homeless intentionally. So that's the decision not to take up occupation. At that time, when he sent the offer letter, the officer is still saying, well, I'm going to find accommodation, I'm going to find a 3-bed for you and your children. So in my submission, there's clear and consistent decision making throughout that he's to be accommodated with his children. And then at paragraph 64, they then set out their reasoning, which is that it wasn't reasonable to expect the children to access temporary housing. You know, that was going to be detrimental to their health and development. That's effectively an attempt to ride back from the decision that they made in relation to priority need, and that they were making throughout that the children had to reside with him. In my submission, it's impermissible and it's inconsistent with their decision throughout, which was that he was in priority need because of the children and that he was always going to live with the children. The room, this is line 3, the room for your sole use provided under 1932 was assessed as reasonable for you to continue to occupy whilst working towards securing long-term accommodation for the household as a whole. So they always accepted and continue to accept that he had to be accommodated with his children.
And you say as a matter of law that is not an approach they're entitled to adopt? Because if it isn't an error of law, we can't interfere.
The error of law is having decided that he is a person who resides with or is reasonably expected to reside with his children. They cannot offer him accommodation which doesn't permit him to do that.
On a temporary basis?
Yeah, at all. Because that accommodation is not available to him. It's not available to the children. And in my submission, it's also not reasonable for him to continue to occupy. It might, and I put it no higher than that, it might be suitable on a short-term basis to separate him from his children. But it's not reasonable to continue to occupy, and it's not available. And then they conclude paragraph 64 by saying, in so doing so, the household's requirement for stable long-term accommodation could have been met, and the children would have been able to transition into long-term accommodation.
Excuse me. Well, I don't know how that happened, but I apologise to everybody.
Very melodious.
It's not 45 minutes.
So then at 65, they then conclude it's not reasonable to continue to occupy. And the same at Roman 4, property was not unreasonable for you to continue. The property was not unreasonable for you to continue to occupy the accommodation. So they can offer it, and they can decide that it's suitable, but it's never available to him, and it's never reasonable for him to continue to occupy, because both availability and suitable to continue to occupy look to the future. So the last thing to look at before I can conclude is the judgment very quickly. Now, this is a homelessness appeal, so we're primarily appealing the review decision rather than the judgment. And in my submission, the judgment, again in the core bundle, page 54, largely falls into the same error of conflating suitability and reasonable to continue to occupy without giving any real separate consideration to the issue of availability. And the relevant paragraphs, I think they've been mentioned before by the court, are 53 and 54 and then 60. So 53, page 54 of the core bundle, right at the bottom, describes the accommodation as a standard no-frills hotel room. The judge then says, I accept it was not appropriate accommodation forever or indeed for the long term, but the council's position that neither was it intended to be. In my submission, that's a misapplication of the reasonable to continue to occupy test, and here the judge is confusing suitability with reasonable to continue to occupy. And then he does that at 54 as well, when he deals with the council's view on suitability. Hotel room is only intended to be a temporary stopgap until more appropriate accommodation was available within a reasonable time. Clearly not ideal, but it was reasonable for Mr. Beach to occupy in the relatively short term or even the medium term before he was more appropriately housed. And in my submission, that's a misunderstand the reasonable to continue to occupy test. Reasonable to continue to occupy is not about the short term. That is suitability. Reasonable to continue to occupy is looking to the future, not in the immediate short term. And then in my submission, he repeats that error at paragraph 60, where he says, looked at in this way, whilst the short-term position was undoubtedly difficult and frustrating, it's difficult to see how the council's position could be regarded as unreasonable. So again, in my submission, that's to fall into the same error as the council and effectively conflate the two tests, suitability and reasonable to continue to occupy, and there's really no water between them if you're going to simply talk about reasonable to continue to occupy being a short-term thing. I want to conclude just by making one comment on 175 and one comment on 176. In relation to 175, if one goes back to the authorities bundle at Ahmed, I'm going to invite the court to read page 305, paragraph 44. I'd like to invite the court just to read the quotation from El Kundi, Statement of the Law by Lord Justice Lewis, because in my submission this neatly summarises the relationship between suitability and reasonable to continue to occupy, and how if something is only reasonable to continue to occupy in the short term, then it's not reasonable to continue to occupy in the legal sense, although it may be suitable. And if I can invite the court just to read from the bottom of 305, top of 306. I'd like to conclude just by going back to section 176 on page 5 to answer my Lord's question, just to make two brief comments on what section 176 means. We're looking at 176b on page 5 of the authorities. I'll make two comments about the meaning of 176b. The first is that it's looking at an expectation, so who might reasonably be expected to reside. So it's not looking at the current situation, it's looking at an expectation, therefore necessarily something that's going to happen in the future. Because if these family members are not residing in the present, then the question is, might they reasonably be expected to reside in the future? And in that sense, it creates synergy with 1753, reasonable to continue to occupy, because it's looking at the future. So it's not permissible for the respondents to decide, on the one hand, yes, the children are expected to reside with the appellant, and then to find at a single point in time, oh, well, actually, at this point, we don't think they're reasonably expected to reside. But I'm not sure they actually reach that decision. I think consistently throughout, they stick to the position that the children should be residing with the appellant. And then to come back to my Lord's question about how does one interpret 176b, I think we've reached the conclusion that it is an objective test, so the council is going to look at whether, in fact, in our case, the children should be reasonably expected to reside, and decided that issue in favour of the appellant. But it's an objective test which takes into account the subjective wishes of the applicant. So in this case, obviously, the applicant wanted to live with his children, and so they had to assess whether that was a reasonable expectation, and they decided that it was. Of course, if he hadn't desired to live with his children, they wouldn't have had to assess the reasonableness of that expectation, because it wouldn't be an expectation of his. And so going back to the example of the applicant who wants to live with his friends, well, that's his subjective desire, but then the authority have to assess it objectively and decide whether it's reasonable for him to be able to live with his 5 friends, and that depends on obviously why he wants them to live with him, whether they're just for friendship or whether they perform some sort of caring role.
It would be quite common in family proceedings for the children to live with one parent and the other parent to have defined contact with them, which might, for example, be alternate weekends, Friday evening to Monday morning. If the question is being considered as at the afternoon of the Monday immediately following one of the contact weekends, do you say accommodation must that night be provided which would be suitable for the children to be there with the applicant, even though they're not going to be for another fortnight?
So, no, I don't say that.
But that seemed to be what you were saying a moment ago when you said that having decided that there's a reasonable expectation the children will live with him, it's not open to the authority to offer accommodation which isn't suitable for them, even on a temporary basis.
So, as I said earlier, these are the sort of Holmes-Morehouse questions about whether or not the appellant's in priority need in the first place. It's not this case, because this is not a case where he's only got a few days a week. He's got the 2 children on a permanent basis. They've been ordered to reside with him. And the respondents agree with that position, and they find that he's in priority need on that basis. They could have decided that he wasn't in priority need because they didn't think, although there was a court order in his favour in respect of 2 children, they didn't think that in fact that those children were reasonably expected to reside with him. But they didn't make that decision. And so in a sense these hypotheticals are irrelevant because they decided consistently throughout that the children should reside with him, and the end game was to find accommodation for him with the children. And it's that expectation which means that the accommodation must be available for the children, because the availability looks to the future. You have to, otherwise, as was said in the representations, you entirely defeat the application. You accept that he ought to be accommodated with his children. You don't accommodate him with his children, and then you turn around and say, you're not being accommodated with your children, so we don't have to accommodate you with your children. Whereas if an applicant applies to the authority with children and they accept he has a priority need with children, they must make accommodation available to him with the children. Otherwise it entirely defeats the decision that they've made in relation to the application.
Okay.
Well, those are my submissions.
Thank you very much. No, thank you very much. Yes, Miss Rowlands.
The position we've reached, having heard my learned friend's submissions, is that his case is that the only way the local authority could have performed its duty to Mr Beach on the 20th of April when he presented, having been thrown out of the travel lodge for being drunk, is to provide him with accommodation that was big enough for X number of children, we don't know how many, even though that accommodation would not be used because those children were, as a matter of fact, living with their mother. Or if they did, provide him with accommodation that was only big enough for him, that was accommodation that has to be disregarded, so that if he trashed that accommodation, failed to pay rent, failed to take it up, whatever he did, he could not be treated as intentionally homeless. He had an entire carte blanche to treat that accommodation however he wished. My lords, that cannot be the reality of the situation. Homelessness is a real-world problem that happens in real time, and it demands real-world solutions in real time. The reality of the situation is that when Mr Beach presented on the 20th of April, he wanted accommodation for himself. And it is only in the mirror of hindsight that we get it reflected as being accommodation that he wanted to have his children living with. The sequence of events shows that Mr. Beach has something of a turbulent nature. He applied on the 24th of November 2022, saying he'd lost his last accommodation.
Sorry, too quick.
I'm sorry.
24th November 22.
Can I take you to my skeleton argument? And I'm starting at paragraph 3. When we finish, my lords, I think it might be useful if I send you my replacement skeleton argument with the page.
Would have been even more useful to send it in advance and make sure it was properly dealt with.
My instructing solicitor did send it, my lord, so I don't know what's happened to it since then.
Right, page. Paragraph 3 you wanted on page 2.
That's right. So this is when he first applied. He found accommodation for himself at that time, but found it unaffordable. We've tried to arrange previously accommodation with a particular provider, the main provider for, I think, the local authority, Live West. They won't accommodate him any longer. The relief duty was accepted by the 13th of January, and we note there that there was some delay because he dropped out of contact. And the main housing duty was accepted on the 27th of March 2023. We've already looked at that letter and noted that it doesn't say why priority need is accepted, whether it be 2 children, 4 children, or however many. But because the appellant was accompanied at that time by his children, he was considered to be in priority need. A series of offers of accommodation under section 188 were made, and you've already been taken to the provisions of section 188. This is the duty to arrange accommodation for someone at the first initial stage, before you have made the decision under section 184 as to what duty is owed to a particular applicant.
Is that what you call the relief duty?
That's right. On the 27th of January 2023, he was offered accommodation, which he then declined and found his own accommodation. Police then intervened and he asked for accommodation, at this stage asking for accommodation for himself alone, the children then having their own accommodation with their mother. A second offer of accommodation was made. This was the Seascapes Hotel for the first time, and that was again declined. He then seems to have moved into a storage container with 2 of the children.
I'm so sorry. I'm trying to follow this. Where do we see something about him asking for accommodation for himself alone?
My lord, there have been, not all the documents are in the bundle. There have been 2 sets of judicial review proceedings as well in the course of the comings and goings that we've had there. But these dates are particularly set out in the decision letter. And then the police found him living in the storage container and took the children away, returned them to their mother. And on the 19th of April, the children were taken away from him. Devon County Council Children's Services were involved, and Devon County Council told South Hams that the children should not be living with their father at this stage. So on the 20th of April, he was offered accommodation at the Travelodge. He went in there for 1 night. Travelodge wouldn't let him stay beyond that. We then come, after that turbulent history, but a history which includes accommodation for him alone on various occasions, to the stage where he is offered accommodation at the Seascape Hotel in Torquay. And you've looked at the red, orange and green rules. In relation to that, it was clear that this was accommodation for him alone, no dogs allowed, and he would have been able to stay there on a rolling basis. And he was advised as well of the consequences of refusal of this accommodation. He was also told, and did not challenge, that the respondent was satisfied that the children were safely living with their mother and did not themselves require temporary accommodation.
I'm so sorry. I just need to see some source for all of this.
Well, this last bit, we can go first of all to page 14 in the supplementary bundle.
Thank you.
So here's an offer of accommodation.
Where does it say it's limited to one adult on this document? I couldn't find it.
Not on that document. It's more on page 21. Page 14 has the annex, which is the red, yellow and green warning lights. And then page 21 makes it clear that this is accommodation for one adult, a furnished room. It also says that the members of your family named on your homeless application can reside in the accommodation provided. That's on page 22 at the top. It then goes on to say, we are satisfied that your children are safely residing with their mother via Devon County Council Children's Social Care, and therefore do not require temporary accommodation at this stage.
But what about the section at the top of that page, which I asked Mr. Van Hagen about, as previously agreed by yourself? Is that recorded somewhere in the documents we have?
When you take up the accommodation, I'm speculating rather than going on instructions or on any evidence. When you take up the accommodation, you will sign up to the rules. The rules you saw at page 14, 15 and 16. So he's already been aware of those rules from previous offers as well. It is accommodation that's offered to him as temporary accommodation, and it is made clear that it is temporary accommodation and suitable for him for that period. That is to say, the temporary accommodation period rather than as a final offer of accommodation. But if you lose this temporary accommodation, it says at the bottom of page 22, as a result of any deliberate act or omission, or if you're not occupying the accommodation, then the council may choose to cease its duty to provide you with temporary accommodation. This means that no further temporary accommodation would be made available to you. When he refused to take up the accommodation, it was not because it didn't accept his children, it was because it didn't accept his dog. This was the first the respondent knew that there was a dog on the scene. It wasn't until May that he raised any issues about the children. He did spend one night at the Seascape Hotel, but then left never to return.
Well, it says in your skeleton that his accommodation was terminated. Who terminated it?
The local authority.
Why did they do that?
Because he hadn't taken it up in time.
So it wasn't. It's because he didn't take it up on the 21st.
Yes.
Even though he did take it up on the 25th.
Well, if we look at what is said in the decision letter, which is back in the core bundle. we go to page 83, starting at paragraph 21. You did not occupy the accommodation, it says in paragraph 23, on the 21st, 22nd, 23rd or 24th of April. And on the 26th of April, you were notified that the decision not to use the accommodation on the dates listed resulted in the ending of the local authority duty toward you under section 193. At the bottom of that page, he's reminded that not only were you warned of the consequences of these actions, but also had previous experiences to complement this information. I have no doubt that you were in full possession of a thorough understanding of the expectation to remain in occupation of accommodation provided to you, and the consequences of deciding not to. And then at paragraph 32, I am satisfied that the decision to voluntarily cease to use the accommodation provided is the deliberate action that caused the loss of the accommodation and the formal cessation of occupation.
Sorry, where's that?
That's the deliberate action, the paragraph 32. At the top of page 84.
When did he voluntarily cease to use the accommodation? He was still there on the 25th.
Well, he went back in on the 25th, but for only one night. But on the 21st, 2nd, the 3rd and 4th, he didn't use the accommodation. So it was his deliberate decision not to use the accommodation provided for him on 4 consecutive nights that led to the decision to terminate the offer of accommodation. For the next 3-4 weeks, he found his own accommodation and did not get back in contact with the local authority. But on the 12th of May, he sought a review of the decision to discharge duty to him. That's in the supplementary bundle at page 31. Because he sought a review, the local authority comes under, has then a power to offer accommodation pending review. It's a power, not a duty, but they have to exercise their discretion as to whether or not to accommodate. In this instance, the local authority did decide to exercise its discretion to offer him further accommodation pending the completion of the review that he had requested. It was again offered at the Seascape Hotel, and again he refused it. It's offered at page 37 in the supplementary bundle, and at page 39 you see that it was Mr. Beach says that he turned up at the hotel to assess the suitability of the accommodation, collect the keys and deposit some belongings, and he was there with one of his children, and the hotel staff told him that this was accommodation for him alone, not that child. And then we go to the judicial review that happened in the meantime at that stage. On the 12th of June, we have the decision to uphold the decision that the appellant was intentionally homeless from the accommodation made available to him in performance of section 193. That decision we've already looked at to a certain extent, and I've summarised it in paragraph 25 of my skeleton argument. And I don't want to labour these points. The point of dispute between us, as identified by Mr. Van Heegen, is that my paragraph 25, I, Roman 1, his children were not expected to reside with him. Mr. Van Heegen takes the longitudinal view of this and says in the long term the children were expected to reside with him, and also the initial view of it. When he applied, the local authority accepted that his children, or at least some of them, were expected to reside with him. I take the immediate view of this. In a real world, on the real-time decision that we are concerned with, on the 21st of April, his children were not expected to reside with him, right there, right then. They were, on that occasion, accommodated with their mother. They weren't homeless. They had accommodation that they could have at that time. The local authority were not expecting to provide temporary accommodation for them, and so when they arranged temporary accommodation for Mr. Beach, on that occasion they arranged it big enough for him and him alone. And I will now turn to the law to show that they were right to do so. I've already made the point that the homelessness law is all about finding real-world solutions to the real-world problem. That is a common theme that runs through the case law that my learned friend has already taken you through, and I will hopefully not labour too many points. But I do want to start really with the case of Oase, or Ali, as it was known before the Supreme Court. Birmingham City Council had decided in relation to various applicants that they were in accommodation that was not right for them in the long term. It was accommodation that was either overcrowded or didn't have the right facilities for a disabled resident within the household, or it was accommodation that was in a bad state of disrepair in one case. And so Birmingham accepted in each case that each of those applicants was homeless because the accommodation that they had was not accommodation that was reasonable for them to continue to occupy indefinitely. That is to say, until the local authority stepped in to do something about it. Nonetheless, it was accommodation that they could occupy for the time being. The option that those people had would have been to stay put in their own homes or to move into transient accommodation, B&B, hotel, hostel accommodation, while Birmingham sought something in the long term. Because what is common ground between me and my learned friend, of course, is that it's not easy to arrange a final offer of accommodation very quickly for, particularly, as was in the Birmingham cases, the larger households. A shortage of large accommodation, particularly in Birmingham, to offer the large families that was there. And so Birmingham left them what became known as homeless at home. So the accommodation that those people were occupying became simultaneously accommodation that was not reasonable for them to continue to occupy for the long term, and accommodation that was secured for them by Birmingham in the exercise of its Section 188 duty. Because as soon as they were accepted as homeless, Birmingham had to secure that accommodation that was suitable for them. Birmingham had to secure accommodation that was suitable for them. What Birmingham did to secure the accommodation was just to leave them where they were. So it was suitable accommodation, and it was also accommodation that was reasonable for them to continue to occupy for the period that they were likely to occupy it. That is to say, until Birmingham found them an alternative long-term solution. And so it's almost like one of those magic eye pictures. You look at it in one way and it just looks like a row of dots, and then you squint in another way and it makes a picture. Looking at this accommodation in one way, it's accommodation that's not suitable, not reasonable to continue to occupy for a long time, but it is suitable accommodation as short-term accommodation. It's simultaneously right and wrong for them. It is right, as my learned friend has made the point, that reasonable to continue to occupy and suitable are not necessarily the same thing, but there is a huge degree of overlap. it's all about finding what is right for the person before the local authority, or considering what they had in the past to see whether that was accommodation in which they were intentionally homeless, see what they've got in the present to see whether it is accommodation that is reasonable for them to continue to occupy, or look to the future to see what suitable accommodation the local authority will secure for them or assist them to secure for themselves. So the difference really between reasonable to continue to occupy and suitable accommodation is the perspective that you're looking at it from, looking back, looking present, looking future. What can be suitable for the person in the short term, not necessarily suitable for them in the long term. What can be reasonable to continue to occupy for a short period of time might not necessarily be reasonable to continue to occupy for a long period of time. And once you accept that point, it is easy to move from there to accepting that you don't have to offer accommodation for the entire family when you're offering temporary accommodation. Once you accept what was said in Awais, that the local authority, in fact in Arua it goes beyond Awais back to Arua, that the local authority can perform its duty in stages, realising that you can do that on a day-by-day basis, you see that the accommodation need only be suitable or reasonable to continue to occupy for that period of time. So it is evident from Awais that reasonable to continue to occupy varies depending on the period for which you are likely to be there.
And just help me with this, if you would please, Rose. How does this work if, for example, the temporary accommodation goes on and on and on because it's just very difficult to find something suitable long term, and the applicant is saying in effect, well look, I've been here weeks now and I still can't have my children with me. You keep telling me it's short term, but there's no sign of anything long term coming. So, I mean, I perfectly well understand the argument of fulfilling the main duty in stages, but how does that sort of living day to day change at any point? In principle, we've gone for years, still saying, well, we're still looking for a long-term solution.
That was exactly the issue in Awais. It had been years. We had, for example, one where the daughter of the family was severely disabled and needed significant adaptations to live comfortably in the property. And it did go on for years. And that was why they brought the case to court, saying enough is enough, we need to be moved now. And they were off asking for an order that they be accommodated in permanent accommodation on a immediate basis, really.
Right.
And so what Lady Hale is dealing with in that case is saying there does come a time when enough is enough, when it ceases to be open to a local authority to say it's not reasonable to continue to occupy, even for another day.
Right, thank you.
Paragraphs 34 to 40 of Awais, the pages 133 in the bundle of authorities.
Which paragraph?
Starting at 34.
Thank you. This is the passage we've looked at already.
And
it is convenient.
Yes, that's right. Paragraph 36, sections 1753 and 1911 are looking to the future as well as to the present. They do not say which it is reasonable for intercompany or was reasonable. It's continued. It looks at occupation over time. And so in paragraph 38, this interpretation has the advantage that the council can accept that a family is homeless, even though they can actually get by where they are a little longer. The council can begin the hunt for more suitable accommodation for them. Otherwise, the council would have to reject the application until the family could not stay there any longer. The likely result would be that the family would have to go into very short-term, even bed and breakfast accommodation, which is highly unsatisfactory. It also has the advantage that the family do not have to make repeated applications. If their application is rejected on the ground that it is reasonable for them to stay one more night, they cannot apply again until there's a different factual basis for the application. How are they to judge whether the council will consider that the tipping point has been reached when this is such an uncertain event? So 2 points to elaborate out of that. What was being argued was, you're not homeless until you really can't stay there one night longer. How do you know when it's really that bad that you can't put up with it one night longer? Obviously, sometimes you're homeless because you've been evicted, you're fleeing domestic violence or whatever it may be, and you're definitely homeless. But in this case, these were people who were overcrowded, struggling in the accommodation that they had. How do they know when it's got to the point that it's just, can't put up with it one more night? And if the local authority rejects them and says that you're not homeless, they can't come back the next night and say, well, now I am, because the circumstances are the same. You can't make a fresh application until there has been a change of circumstances. And the case law on that is a case called Rika Begum and Tower Hamlets. And so it's not quite right what Mr. Van Heegen said about Mr. Beach being able to make a fresh application. He would only be able to make a fresh application if there was a relevant change of circumstances, such that South Hams would have to accept a new application from him. South Hams could legitimately say, your circumstances are the same as they were when we rejected your application before, and you haven't shown any change of circumstances whereby we should accept a fresh application. Paragraph 40 in Oase, it is true that if a family have no home and are on the streets, the authority's duty under section 188 to provide them with temporary accommodation immediately accords with practicality and no doubt the family's wishes, but the position will often be different in a case where the family have accommodation. They may well prefer to remain where they were while their application was being considered. As Mr. Justice Collins said at first instance, they may prefer to remain in unsuitable accommodation for a short time rather than move to temporary accommodation. And there should be discussion leading to agreement and no compulsion. However, the combination of section 1881 and section 206(1) means that the council's interim duty under section 188 is to provide suitable accommodation. If an applicant is occupying accommodation which it's unreasonable for him to continue occupying for even one more night, it is hard to see how such accommodation could ever satisfy section 1881. Section 1753 obviously includes such cases but does not have to be limited to them. And then over the page, paragraph 42, given that an authority can satisfy their full housing duty under section 193 by providing temporary accommodation, which must of course be followed by the provision of further accommodation so long as the section 1932 duty survives, these observations clearly do not only apply to section 188. They emphasise that accommodation which may be unreasonable for a person to occupy for a long period may be reasonable for him to occupy for a short period. Accordingly, there will be cases where an applicant occupies accommodation which A, would not be reasonable for him to continue to occupy on a relatively long-term basis, which he would have to do if the authority did not accept him as homeless, but B, it would not be unreasonable to expect him to continue to occupy for a short period while the authority investigate his application and rights, and even thereafter while they look for accommodation to satisfy their continuing section 193 duty. And so the same accommodation might be reasonable and unreasonable, suitable and unsuitable at the same time. But what you don't get from that is any support for the contention made by Mr. Van Heegen that accommodation for must include accommodation for whatever number of his children he then wants to have accommodated with him. And I have to say there's no clarity at any stage as to how many of those children it might be. because different standards apply at different stages. It might be less suitable, something that you can put up with for a short period of time when it comes to temporary accommodation, as opposed to the final offer of accommodation, the final suitable offer that will lead to discharge, that is to say, bringing to an end the local authority's duty under section 193. Who is reasonably to be expected to live with the applicant is a question that is raised by this appeal, and you have in the bundle of authority the case of Holmes Morehouse. And Holmes Morehouse is another example of the court's finding the real world solution to a problem that arises in homelessness cases. And this is a case that's very often cited in homelessness appeals for the dicta of Lord Neuberger that tell you to take not a nitpicking approach to interpretation of decision letters of local authorities. But in this case, we can look at it for the real ratio of the case, which is about when you've got the kind of circumstances that my Lord Justice Holroyde just raised about a child living between two parents. This is exactly what was under discussion in Holmes Morehouse. In Holmes Morehouse, in fact, the order of the court, this had been agreed between father and mother, was that the children would split their time evenly between them. And Lord Hoffman set out the issues in that case and noted that the family court and the housing authority are doing different jobs. What the housing authority is doing is deciding who has priority need for accommodation arising out of the children of the family, whereas the family court is deciding what the best thing for the children are, having regard to the children's welfare as the paramount consideration. At paragraph 9 on page 108, the question for a housing authority under Part 7 of the 1996 Act is not the same as the courts. In deciding whether children can reasonably be expected to reside with a homeless parent, it is not making the decision on the assumption that the parent has or will have suitable accommodation available. On the contrary, it is deciding whether it should secure that such accommodation is provided. And this brings in considerations wider than whether it would be in the interests of the welfare of the children to do so. The fact that the court and the housing authority apply superficially similar criteria does not mean to say that the questions are the same. The contexts are quite different. Housing authorities applying the provisions of the Housing Act, not the Children Act. The question of whether the children can reasonably be expected to reside with the father must be answered in the context of a scheme for housing the homeless and answered by the housing authority in which the statute vests the decision-making power. There was some dispute about whether the words might reasonably be expected referred to the expectations of the applicant or those of the council. The Court of Appeal thought it meant that the applicant's expectations had to be reasonable. Paragraph 19, the council said it referred to what as an independent body would consider reasonable. I think that this is a barren argument because the phrase clearly refers to an impersonal objective standard. It is therefore unnecessary to ascribe the expectation to anyone in particular. The question is rather what considerations does the Act require or allow to be taken into account in deciding whether one person ought reasonably to be expected to live with another. The phrase clearly appeals to an objective social norm. And then we go on to questions about what might have been normal in 5th century Sparta. And again at paragraph 12 over the page, the social norm must be applied in the context of a scheme for allocating scarce resources. And at the bottom of paragraph 13, round about letter G, the standard must necessarily take account of the way in which, given the scarcity of housing, many people nowadays have to live. Section 1772 enables different standards to be applied by different housing authorities according to their different local situations. So the question which the housing authority therefore had to ask itself was whether it was reasonably to be expected, in the context of a scheme for housing the homeless, that children who already had a home with their mother should be able also to reside with the father. And in answering this question, it would no doubt have to take into account the wishes of the parents and to the opinion of a court in family proceedings, but it would be entitled to decide that it was not reasonable to expect children who were not in any sense homeless to be able to live with both mother and father in separate accommodation. So the question as to reasonably expected to reside is one for the local authority to determine, having regard to the objective impersonal social norms and having regard to the evidence before it, of course. And the evidence in this case was that Devon County Council told South Hams that the children were not to be expected to live with their father. They were, at the time of this decision, the offer of this accommodation, they were expected to live with their mother. That doesn't take away from the fact that the local authority had decided that they were in priority need, that Mr. Beach was in priority need. My learned friend is right, I think, to say that once the local authority has decided that the full housing duty is owed, it's only in exceptional circumstances that a local authority can resile from that. There are certain exceptional circumstances. Fraud is one, and a fundamental mistake of fact is another. It might be possible for a local authority to say, when we decided that you were in priority need, we were under the mistaken belief that your children were going to live with you. We now know that's not the case, so we no longer think that you're in priority need, and we're going to reopen the Section 184 decision. We haven't done that in this case. It would be possible, I think, to answer that dilemma in that way. But I say that that does not mean that the performance of the duty to Mr. Beach as someone on that occasion in priority need for accommodation owed the Section 193 duty, but presenting to be accommodated with his children living with their mother, him the only person in need of accommodation, meant that the local authority had to do an artificial exercise of securing accommodation big enough for the children that weren't living with him. Performance of the duty is, in the real world, in the real time, determined by what actually is needed, what is suitable accommodation for him at that time. My learned friend says what's suitable is irrelevant. It's not irrelevant because what we're talking about in the first place is how he gets into this accommodation. It's offered to him as suitable accommodation. It's suitable for him because he's there. He can occupy this hotel room for a short period of time or a longer period of time, depending on how things go, but with no reason why he would have to move out at any particular stage. And he can live there until things have been sorted out, where the children are going to live, where he's going to live, all those sorts of things, and an offer of long-term accommodation can be made. My learned friend says it's not reasonable for him to continue to occupy because it's not something that can be his home. In N and Lewisham, the Supreme Court had to consider that aspect of it as well, and again came to a practical and real-world solution. N and Lewisham starts at page 156 in the Bundle of Authorities. And what their lordships were discussing in this case was the need for temporary accommodation to be protected by the Protection from Eviction Act, so that local authorities who offer temporary accommodation like this would need to take court proceedings to evict people in circumstances where they wanted to get them out. And in a nutshell, they decided that temporary accommodation offered to people as a result of the homeless application was in a case of its own, because it didn't attract the protection of the Protection from Eviction Act, and it wasn't a home within the meaning of Article 8 of the European Convention on Human Rights. If we can look, please, at page 177 and paragraph 70.
I'm terribly sorry, but before you go there, could you just say what is the proposition that you say the passage we're about to look at supports?
Well, my learned friend said it can't be reasonable to continue to occupy because it's not something that he can call his home. My counter to that is it doesn't matter that he can't call it his home, because temporary accommodation is not supposed to have the character of a home.
Yes?
So paragraph 70 and
70.
70 and 71. And indeed, the whole of that judgment makes it clear that, so that's the Court of Appeal rather than the Supreme Court there. And
I'm on page 206. Where should I be?
so I was looking at page 177 within the Court of Appeal's judgment there, which was, you've got the two judgments run together here. Perhaps if I go to forgive me, I've been I think what I've done in paragraph 30 of my skeleton argument is simply to summarise N and Lewisham and tell you what the points are that I am putting forward arising out of N and Lewisham.
Paragraph what?
Paragraph 30 of my skeleton. And I think moving on from that means that we have in our minds the submission that accommodation doesn't need to be something that you can call a home in order to be reasonable to continue to occupy. It can be temporary, transient accommodation. And that brings me then to Kyle, when we were considering a very similar type of accommodation. Although it wasn't a question of children in that case, it was a question of accommodation where Mr. Kyle argued that he wasn't able to treat it as a home. He wasn't able to live as he would want to live. In that case, stealing from other people. It seems he was nonetheless intentionally homeless when he lost the accommodation which he had been offered. It was accommodation like this offered under section 193 of the Act. It was accommodation that was offered to him on an indefinite rolling basis, again like this. And Lord Justice Nugee's judgment starts, if I can start at paragraph 36 on page 326 of the Bundle of Authorities. Lord Justice Nugee summarised the points that emerge from Awais and Moran. The reasonableness and suitability are distinct, but they do throw a light on each other. They are perhaps two sides of the same coin. He said then, I touched on one aspect of this.
Paragraph?
Paragraph 47 of my judgment in Ahmed.
47.
Thank you.
There's no question of Baroness Hale having meant that accommodation had to be available indefinitely for it to be reasonable to continue to occupy. Her concern was whether a person could be expected to put up with accommodation indefinitely or for so long as he or she will have to do so unless the authority take action, to quote from paragraph 46, not with ensuring that the person will be able to remain there indefinitely. She was not suggesting that for it to be reasonable for a person to continue to occupy accommodation, the person had to be able to stay there indefinitely, meaning world without end, or even for any particular period of time. And down at the bottom of that page, paragraph 39, the word indefinitely can of course signify without a limitation as to time. Whilst, however, indefinitely featured at a number of places in Baroness Hale's judgment, she also spoke of for the foreseeable future, for as long as she would occupy it if the local authority did not intervene, the length of time that they would have to stay there if the local authority did not intervene, for a long period on a relatively long-term basis, and so on and so forth. Compared with a little while longer, a short period while the authority investigated application and rights, and even thereafter while they looked for accommodation to satisfy their continuing section 193 duty, and a little while. That accommodation need not be such as could be tolerated forever is also indicated by Awua. It can be seen that Lord Hoffman considered that there could be circumstances in which it would be reasonable for a family to continue to occupy accommodation, even though there would come a time at which it was no longer reasonable to expect them to continue to occupy such accommodation. Had it been the case that accommodation must be such as could reasonably endured permanently, the fact that such a family could be expected to make do for a temporary period would not have sufficed to render the accommodation such that it would be reasonable to continue to occupy it. In paragraph 41, we note that there is no question of the potentially relevant matters being limited to the physical characteristics of accommodation. Awais Moran provides an illustration of that. There were issues about the special nature of the refuge, and it had its own special quality of a safe or temporary haven rather than being as a place to live. I would submit at this point as well that means that relevant matters include whether the children have got accommodation somewhere else. And then at the bottom of that page, paragraph 42, Lord Justice Nugee draws the threads together and says there's no need for accommodation to be so bad that a person couldn't be expected to stay there another night, for there to be homelessness. On the other hand, a person doesn't have to be entitled to remain in accommodation indefinitely for it to be reasonable for him to continue to occupy it. And neither need he have accommodation which it would be reasonable to continue to occupy forever. The physical characteristics of accommodation will often be of central importance. Restrictions affecting the person's life in the accommodation may also be relevant. Possibly the length of time that a person has the right to remain in accommodation may sometimes be of significance, but that is much less likely to matter. Other factors that might be material, depending on the particular facts, include affordability, violence, abuse, and threats.
If you go back to 42.1, the last sentence of that, Lord Justice Nugee says, in general, a person will not be homeless if there is accommodation which would be reasonable for him to continue to occupy over the period which would elapse before the local housing authority rehoused him.
Yes.
How do we know how long a period that is?
Well, you can never tell. It's indefinite in the sense of not having a definite period to it. But
So how long is it in practice?
It depends on the local authority. I can't speak for South Hams. This is the only case I've been instructed by them on.
I suppose one approach to it is to say you know it when it's too late, because if you take the Baroness Hale's approach, there comes a point where you just say this is unreasonable, but you can't predict in advance how long that's going to be. Is that
absolutely right, yes. In two of the cases in the Oase cluster, we ended up having run-offs afterwards, after we'd been to the House of Lords. And in one of the cases, it was accepted that we'd taken too long, the Birmingham had taken too long to find accommodation for, it was the Oase family, and paid compensation for that. In another one of them, Omar, the local authority was upheld. They had not reached the stage where it was no longer reasonable.
So you would accept in principle that although you submit that the offer in April was a reasonable offer, or an offer of accommodation which it was reasonable for him to continue to occupy, that offer being made, as we now know, with an underlying contractual basis of 5 days initially extendable, you I think would accept that if, say, he'd been there 2 years later, still extending 5 by 5, I'm taking an extreme example, there may, during that period, have come a time when someone would say, this is no longer reasonable to expect him to continue to occupy.
Maybe it would depend on all the other circumstances.
Yes, I don't, but I'm just trying to give you an absolutely extreme example.
If this was a case where the children had nowhere else to go, that might happen 6 months down the line, for example. The children were with their mother. She had accommodation that we also know was not perfect for them. And it might have come out of the blue later that she could no longer accommodate them.
Yeah.
And then it would have been.
But I mean, you can play with hypothetical facts
Absolutely.
till the cows come home. But I think, picking up on what my lord said, you would accept that as a statement of principle, while acknowledging that you may not be able prospectively to know how long it would continue to be reasonable.
Yes.
And so you have to apply hindsight when someone comes along and says it wasn't reasonable. You then may have an argument.
Yes.
Okay. Thank you.
So, going back to Kyle, he was offered accommodation which was suitable for him and which was be reasonable for him to continue to occupy had he not lost it because of his bad behaviour. So similarly, that was not accommodation that was analogous to the refuge, as my learned friend has argued in this case as well, because it didn't have that character, the special characteristic of a haven, a refuge, even though he had to put up with some rules and regulations. After all, we all have to put up with some rules and regulations wherever we live. We can't just do anything, even if we're homeowners.
Mr. Van Heegen, on his ground one, which has nothing to do with the children, as I understand it, Mr. Van Heegen says, a hotel room where you can't have a fridge or a microwave, there's no kitchen facilities, and so on, there's not really a place to live. It may give you shelter, but it's not really reasonable for you to expect to continue to occupy it.
I say Kyle is the first answer to that. It was pretty much the same type of accommodation there. You've also got the other examples of Hodge and Hamed in relation to that. Accommodation that gives you the minimum is all that is required to meet the requirement of accommodation that can be reasonable to continue to occupy. And the point, again, I go back to N and Lewisham, it doesn't need to have any characteristic of being a home or anywhere where you can really nest, if you like, for it to have that characteristic of being reasonable to continue to occupy, because the alternative is the street, and that's not a good alternative. It is accommodation that's reasonable to continue to occupy for the period until something better turns up. And something better was turned up by the local authority in this case. And so in terms of accommodation, it really has to be very low standard of accommodation before it stops being treated as accommodation for the purposes of whether you're homeless and whether you are intentionally homeless from it when you lose it. Because that's what this case is about. Let us not forget this is a case of intentionality. Was Mr. Beach intentionally homeless when he broke the rules of the accommodation that required him to stay there on the nights in question and thereby lost the accommodation? Or was this accommodation that must be disregarded for the purposes of accommodation? And my learned friend says it was not accommodation. It falls within section 193 B. Sorry, 6B, I should say. So at page 21, you've got the wording of section 193 6B. The local housing authority ceases to be subject to the duty of the main housing duty under this section if the applicant becomes homeless intentionally from the accommodation made available for his occupation. This accommodation, the hotel room, was made available for him. So my learned friend is... It strikes me as well that you've got a slight difference between section 1932 at the top of the page. The duty is to secure that accommodation is available for occupation by the applicant. And then under 6B, you've got homelessness intentionally from the accommodation made available for his occupation, not secured. I don't know if anything arises from that. I have to be frank, just notice the difference in wording. So my learned friend says that it wasn't made available for him because it wasn't available for him. And available is determined by section 176. And you find that one, of course, at page 5 in the bundle. Accommodation shall be regarded as available for a person's occupation only if it's available for occupation by him together with any person who normally resides with him as a member of family or might reasonably be expected to reside with him. And references in this part to securing that accommodation is available for persons of occupation shall be construed accordingly. So he takes from that the accommodation offered must be available for the whole family regardless of whether or not they are in fact going to occupy it or not. I say that the answer to that is it must be made available for anyone who's likely to be residing with him for the purpose for which that property is occupied by him. It is
Sorry, can you say that again?
Available for the purpose for which that property is occupied by him or offered to him, if you prefer.
Well, which do you prefer?
Let's say offered to him.
That fits with the general structure that we've been getting of offers being tailored to the present situation, whatever the overriding. Right. So in your formulation that you've just done, it matters what the formulation is, unless the formulation is itself a breach of duty, as Mr. Van Hagen would submit.
In the real world, it was available for him for what he wanted for that night. So it was offered to him in performance of the duty under section 193 in that it was made available for his occupation, with everyone who was expected to live with him that night, that is to say nobody else.
Well, hence the explanation is about the dog.
Yes. Didn't know you were going to bring a dog along.
But the fact that he doesn't complain that he can get his children there is not in April is not determinative. It's of some evidential value that to support your submission that the purpose of that accommodation was never to have the children, was not to have the children there. But you can't go much further than that, can you?
Yes, I mean, if you look at the whole course of conduct, you had the previous request for accommodation for him alone, you had the previous offer of accommodation for him alone at the Travelodge, and you had various pointers to the fact that the children were coming in and out of his care. So conduct before and after is evidential but not determinative. And the other thing about section 176 is, in my submission, it contemplates fluctuations. Of course, circumstances can go up as well as down. You might have more children than you did when you first set out. If my learned friend's submission is right, then the local authority could offer someone accommodation for just the 2 children if, in the meantime, you'd had another set of triplets, and they would not have a right to complain. In another case I was involved in, Safi and Sandwell, the local authority failed to look into the fact that the lady was pregnant when deciding whether or not she was overcrowded. So she was deemed to be homeless, having regard to the fact that she had the child on its way. Because having regard to those circumstances, it was not reasonably expected to continue to occupy the overcrowded accommodation anticipated. So it's a question of finding or considering what accommodation is right for a particular person. Suitable, reasonable, continue to occupy are all about the right accommodation. And what was right for Mr. Beach on this occasion for this period of time was accommodation which didn't include his children, because they had accommodation elsewhere. In Always, Birmingham had secured accommodation for their homeless applicants. It happened to be the same accommodation that they already had. Birmingham secured it in the sense that they'd left them there, knowing that it was reasonable for them to continue to occupy that for the period of time for which they had it. In this case, South Hams had secured accommodation for Mr. Beach, and had secured accommodation for his children as well, because they knew that they were accommodated with their mother. They had accommodation open to them for the period of time for which they were likely to continue to occupy it. And so looking at the decision, at the end of the day, it was likely that Mr. Beach would have been offered accommodation that was big enough for him and at least some of his children to live together. It wasn't clear at that stage how many it would be. That decision would have been made at the time when it came to offer accommodation in discharge, final discharge of the section 193 duty. So it might have been accommodation for 1, 2 or 5 children, depending on where he was at that time. If that is right, then it must be right that the accommodation offered to him on this occasion was accommodation that was reasonable for him to continue to occupy, as well as being suitable for him in performance of the local authority's duty at that time. It's all about finding the realistic solutions. In the most recent statistics, which were published yesterday, it was noted that the price of temporary accommodation has gone up to £20 billion over the last 5 years. The 10th biggest provider of interim accommodation is Travelodge. They get £26 million from local authorities over the last 5 years for providing temporary accommodation. Temporary accommodation is a real issue for local authorities, and it has to be done on the most economic way possible, as well as what is right for the family in question. If the children have got accommodation with their parents, Sharif tells us that it is legitimate for the local authority to look at that. Holmes Morehouse tells us the decision as to who is expected to reside in particular accommodation is a question objectively to be determined by the local authority. That is exactly what the local authority did in this case. They examined the facts. The facts were that Mr. Beach needed accommodation, his children did not. His children, Devon County Council had decided, should not at that time be residing with him. And so, although he remained in priority need, and there's no question of resigning from that at the moment, the performance of the duty to him at that time did not imply the performance of accommodation in the final duty sense of being big enough for the children as well. My Lord, I don't know if there's anything further you would wish me to address you on.
No, thank you very much.
In that case, that concludes my submission.
Thank you. Yes, Mr. Van Heegen.
My Lords, can I come back briefly in relation to correcting issues of fact and law? I want to correct an issue of fact, first of all, which is fundamental to the whole case. If one goes back to the supplemental bundle, page 60.
60.
60.
Thank you.
So we've looked at this before. This is part of the letter of representations from the appellant's solicitors on the 7th of June 2023. My learned friend says that the children were with their mother at the time of the offer, and therefore they weren't reasonably expected to reside with the appellant. And that's not right, because if one looks at page 60, we've got the chronology. So they were with him, and then on the 19th of April, they were found in the storage containers. They were taken off him for that night. And then, if one skips down to the 21st of April, so it's the 4th paragraph, Appellant advises he travelled to Roborough Travel Lodge, stayed there with his dog. The following day, so it's the 21st of April, he was told to go to the seascape, booked without his children. And he, next paragraph, initially accepted, but then he didn't. And next paragraph, he didn't hear back from the housing officer. He was unable to arrange anywhere for his dogs to stay at such notice. So instead, he self-funded hotel accommodation over the weekend. 2 of his children stayed with him. So at the relevant time, he was with his children. It's just not right to say, as a matter of fact.
We can't reopen the facts at this stage. The facts are as found in the decision letter, not those submitted by the appellant in the course of the review procedure.
Just a moment, please.
It seems to me both are losing sight of the fact. The question is whether paragraphs 42 and following of the decision letter disclose an error of law. She's right. She's wrong to interrupt. She's right. We can't do that.
I think it's best if we just focus on the issues of law that arise, Mr. Van Heegen, and really you're challenging the decision of the judge, which you said earlier really comes back to challenging the the review decision that on issues of law we sought elucidation as to the facts. I'm afraid, speaking for myself, I feel none the wiser than I was at 10:30, but there we are. And it's, if you've asked us to look at this page, it's certainly not the case, I would imagine, that the appellant was arrested so that the police officers could speak to the children without him. That is not a ground of arrest I've ever come across.
My submission in response to my learned friend, she can't come to this court and assert that the children were with the mother when there's no factual finding. And in fact, what appears to have been the case is that it was the contrary, and they were with the appellant.
No, but you've got to deal with the fact that paragraphs 42 and following set out the basis upon which the local authority made their decision. And there is at the moment in this appeal no challenge to the factual basis. So the question for us is, does what we see in paragraphs 42 to 53 disclose an error of law? Now you've tackled that by saying once you've decided priority need, you've got to treat them as if you're satisfying the entire priority need at all times. And we've got that dispute. But I think, speaking for myself, by the sound of things for my lord as well, if you're going to go into the facts, you're opening up a new head of appeal, which at the moment is not before us.
Look, I accept that the facts are as in the review decision, but there's just, it's not open to my only friend to say to the court as a matter of fact that the children were with the mother, because that in my submission is not right as a matter of fact, and it's not found as such in the review decision. I agree with my lord that really we're no wiser on this. So we really, looking at the case as a whole, it may be unclear as to where the children were. So one can't assert with any certainty that they were with the mother. In fact, as I've shown on page 60, there seems to be evidence they were with the father. So it can't be said that the justification for providing accommodation only for the appellant was that the children were residing with the father. But I leave the point there. So that was the point of fact. And then as for points of law, my learned friend refers to three main cases: Ali, Holmes, Morehouse, and N. And in my submission, those cases have not been fairly represented to the court. So starting with Ali, in my submission, it's simply not the case that reasonable to continue to occupy is concerned with occupation for another night. And we get that in Ali at paragraph 47. And this is on page 136 of the authorities. It's a very important distinction between the two tests. Suitability is concerned with, is the accommodation so bad that you can't reside there for another night? And we get that in paragraph 47. It's page 136 of the authorities. Line 2, there will come a point where they could not continue to occupy for another night. The council would have to act immediately. And that's a test of suitability. And paragraph 47 is then concerned with the issue of suitability. Suitability varies over time. So what might be suitable in the short term can become unsuitable. So one can slip in and out of suitability. The same is not true for reasonable to continue to occupy, because it looks to the future. So you don't slip in and out of reasonable to continue to occupy. Otherwise, when someone applies, the authority might accept them as homeless and then say, oh, well, now actually we've decided you're not homeless. Oh, now we've decided you're homeless again, depending on what accommodation they're in. It makes no sense, because the answer to this is paragraph 46, which is that the authority is entitled to find at a single point in time that they are in accommodation that's not reasonable to continue to occupy and therefore are homeless, and treat the application on that basis. And then that opens up the duties that we've already seen. So the 1881 duty to provide accommodation, they have to carry out housing needs assessment, they have to accept the relief duty. That's all on the basis of the applicant being homeless. And homelessness is not like suitability, where it sort of changes over time, and the authority after a few months can say, well, actually, now we don't think you're homeless anymore. That's not how the system works. So in my submission, there was an error in the presentation of the test. It's suitability, which is the one where one assesses on a continuing basis as to whether accommodation is suitable. But for reasonable to continue to occupy, because it's looking into the future, it doesn't vary over time. So that's Ali in paragraph 47. The next case was Holmes Morehouse, and as I said in my submissions, and I repeat it, Holmes Morehouse has got nothing to do with this case, because Holmes Morehouse is a case about priority need. And if one looks at Holmes Morehouse in the authorities, we can see that from paragraphs 2 and 3. It's page 106 of the authorities. The present case has got nothing to do with the question of whether the appellant is or is not in priority need, because the respondents accepted on the 27th of March that he was in priority need, and they've never sought to resolve from that decision, although my learned friend says they might have been able to do so, but they haven't done so. Paragraph 2 on page 106 says that, right at the end, the council accepted that he was homeless, but not that he had priority need, and the father requested a review of that decision under section 202, and the council affirmed that decision. And then paragraph 3 sets out the list of people who are in priority need. And what this case is dealing with is the circumstances in which an applicant may be in priority need. And the ratio of this case is as if there's a shared residence order, which is described in paragraph 1, then the authority are entitled to decide that the applicant father is not in priority need because the children can reside with the mother, not necessarily with him. So this all goes to priority need. It doesn't go to the question in this case, because in this case the respondents have accepted that he's in priority need. And then my learned friend referred to N and Lewisham. And N and Lewisham is again a case which has nothing to do with the present appeal, because it was looking at not 1932 accommodation as in the present case, but 188 accommodation. And the ratio of N is that 188 accommodation is not a dwelling, and therefore the Protection from Eviction Act doesn't apply. And so the authority doesn't need a court order to evict the applicant from 188 accommodation. And we get that from paragraph 45, which is on page 198 of the authorities. N says nothing about of relevance about 1932 accommodation, because it's not about 1932 accommodation. It's not about reasonable to continue to occupy, and it's not about whether 1932 accommodation can be a home. And so my submission, it takes my learned friend no further. So I quite accept the proposition that what an applicant needs in terms of housing can change over time, and that children leave the accommodation and applicants have children. But that's not this case. The appellant's case was decided initially on the basis that the children were going to reside with him, and it was always the respondent's case that the children were going to reside with him, and that they were looking for accommodation to enable him to reside with the children. And therefore my submission is not open to them at a single point in time to say, well, today we're just going to give you accommodation alone because we don't think the children might reasonably be expected to reside with you. Because the expectation involves looking to the future as a reason to continue to occupy. Section 1932 is about making accommodation available. And in my submission, that means available to the applicant, available to the members of the household who you accept that the applicant is living with. And if you provide accommodation to someone you accept should be living with their children, but that accommodation doesn't enable them to live with their children, then my submission is not available to them. And it's also not reasonable for them to continue to occupy. One of those are my submissions in reply.
Thank you. I just want to ask about this ground of appeal. Just want to ask about the ground of appeal. Any questions? Mr. Van Heegen, could you look at the core bundle, please? Page 26. paragraph 10 identifies two grounds of appeal. First of which is a room in a hotel can never be reasonable to continue to occupy indefinitely. Is that still an accurate statement of your ground one?
No, we haven't pursued that part of ground one. What we've done is pursued a much more narrow ground one, is that the accommodation in this case was not reasonable to continue to occupy.
As part of ground one or as part of ground two?
As that is ground one, that the accommodation in this case was not reasonable to continue to occupy. So ignoring the characteristics of the appellant entirely. And then ground two...
But I'm sorry, ground one, in the application for permission to appeal, ground one was being put forward as a case of an issue of general importance, which would affect potentially many homeless applicants. Paragraph 3 of the document, or a document, paragraph 3 of your grounds of appeal. This is an important issue of wider public importance because so many homeless applicants are accommodated in hotels. The outcome of this appeal is likely to affect the thousands of people who are living in rooms in hotels. Should we ignore that?
No, because if we're right that this room in this hotel is not reasonable to continue to occupy, then of course that has implications for other rooms in other hotels. But I can't make submissions on hotels generally, rooms in hotels generally. I must confine my submissions to the accommodation in this case. But of course it has wider implications because ground one is nothing to do with the appellant's own characteristics and goes to the nature of the accommodation per se.
Right. Thank you. We'll just rise briefly to take stock. Thank you very much.
Nice to see McGraths on the other side. McGraths. I mean, when I started off at the bar, McGraths were my regular opponents on disrepair claims and Section 82s.
On the Section 82s,
Yeah.
yes, they're still doing it.
Just downstairs from Birmingham's offices, and used to go up and distrain on the desks when Birmingham didn't pay the judgment debts. When did that happen?
4 years ago.
Is Graham retired?
Yes.
Do sit down, both of you. Thank you. There's one matter we would like to be dealt with, and Mr. Van Heegen, it applies to you. Could you, by 4 p.m. on Friday, unless you tell us you're going to need more time, just provide us with a very succinct note of how we should understand ground one to be stated? I think that'd be very helpful.
Yes.
Thank you. Does that give you long enough?
Oh, yes, yes.
Yeah, thank you very much. Then we'll await that with interest. We will, unsurprisingly, reserve judgment. We will provide a draft or drafts, as the case may be, in the usual way for the correction of typos and so on. We will expect thereafter to be able to hand down remotely. So when the draft is circulated, we'd be grateful if Council would try to agree an order and any consequential matters, and if there's anything which proves intractable as between the parties, then brief written submissions, please, with a view to our endeavouring to decide everything without a further hearing. Anything else which either of you wants to raise at this stage? No, well, thank you both. I'm sorry that movements in and out of court are not much of a spectator sport.
Well,